At the core of my paper is a model, a strategic model of liability avoidance. Employers use this method, many of us believe, to lower the possibility of an adverse ruling against them, and if there is an adverse ruling, decrease the possibility of a large damages award. So that's the context. And with that, we're going to go through a series of pictures that bring to life this rather dull and mundane topic of a partisan election of judges. When we're talking about that, we're talking about state judges, and I'll have more to say on that. But I want to put this in context. So we're on this path. This is part of the winding trail that we're going to take today that leads to the research that the preliminary research that I've developed. You'll recall that in April, there was a mine disaster in southern West Virginia. 29 miners were killed. An explosion caused their deaths. The employer was Massey Energy. Massey Energy has a long history in West Virginia and Kentucky. I can't tell you when, but I can tell you about 20 years ago, there was a speaker standing right here talking about a major dispute in West Virginia involving A.T. Massey. A.T. Massey at that time had mining operations in South Africa and Brazil, and basically was telling the United Mine Workers, folks, you got to work 9.5 hours without any lunch, and if you don't, we're going to shut down this mine and take it to, invest more in South African mines and Brazilian mines. For a long time, Massey has been a major player in the coal markets, a tremendous producer, but always a controversial figure with respect to its ability to escape regulation. Many United Mine Workers representatives will tell you that there's an informal relationship between that mine management and between OSHA, and they're tipped off when there's an inspection on the way, and that's why we get the results that we get here. But I didn't come to talk about that. I came to talk about the president and here we have another picture showing the funeral, one of the funerals in procession. But I came to talk about a very unique kind of election. And it involved this gentleman over here. His name is Don Blankenship. He is the CEO of this multi-billion-dollar corporation called Massey Energy. And Mr. Blankenship was involved in a case that went before the U.S. Supreme Court some time ago. Not some time ago, excuse me, in 2009. You have before you the West Virginia Supreme Court. And that's, I think, the right place to tell our story about partisan elections of judges. This gentleman here is Justice Brent Benjamin. Mr. Benjamin received very substantial support from Mr. Blankenship and from Massey. I'll throw the figures up on the board, but let me give you the outline, and then you can see the specifics of this. The specifics are that Massey was involved in a lawsuit with another coal producer. That producer, headed by a man named Hugh Caperton, that producer claimed that Massey had cheated them out of a contract, a supply contract with a steel manufacturer, and it caused $50 million in damages. This was a civil lawsuit. The lawsuit went before a local court. That judge happened to be an elected judge. That court and the jury found in favor of the plaintiff Caperton and awarded $50 million in damages. Massey and Blankenship appealed the judgment. While the case was on appeal, Blankenship sought support from Massey and received very substantial support. And let's get some facts and figures on the board for you here. Computer's a little slow. All right, well, Blankenship made a $1,000 contribution directly to Benjamin's campaign committee. He also contributed $2.5 million to a campaign called And for the Sake of the Kids, and who wouldn't give to that worthy cause? This interest group opposed Benjamin's opponent, Justice McGraw, and supported Benjamin. And interesting to note, Blankenship contributed 2/3 of the total funds to this campaign. In addition, Blankenship spent over $500,000 in direct mailings and TV ads to support Brent Benjamin, who, by the way, had not served up until this time on the West Virginia Supreme Court. So you had a situation where Blankenship contributed $3 million in contributions, clearly outspent anybody else in this campaign, and by all outward appearances appeared to be buying a justice on the West Virginia Supreme Court. Benjamin won. It was a close race. He got 53% of the vote to 47%. And in fact, this story was so intriguing that John Grisham made it the subject of his 2008 novel, The Appeal. Well, the Supreme Court, I don't know if they read Grisham, but they did read the petition for certiorari. It's a petition to review a lower court decision. Mr. Caperton said, this is a miscarriage of justice. After Justice Benjamin was seated on the West Virginia Supreme Court, Mr. Caperton's attorneys made two separate motions for recusal. This is an action where a judge, faced with a conflict of interest, removes himself or herself from a position of making a decision. On two separate occasions, Justice Benjamin denied the motion. Procedurally, West Virginia allows a judge to rule on a motion to recuse himself directly. That is to say, when that motion's made, another set of judges does not make that ruling. Well, the case went forward on appeal, and the case, the verdict was reversed. The $50 million judgment was reversed, and Justice Benjamin cast the deciding vote. You can see why it became the subject of a novel. You know, Grisham isn't as imaginative as you might think. All you have to do is dig deep and you'll find a good story here. And this went to the United States Supreme Court in 2009, just a year ago. And as has been the case in controversial instances, Justice Kennedy supplied the tipping vote. And he ruled that this violated the due process rights of this litigant, Mr. Caperton. He said it was an extraordinary situation, but he looked at the size of the expenditures compared to others in the campaign, and he said the apparent effect of such contribution had on the outcome of the election would give rise at least to an inference of judicial bias. And I think that frames the research question that I'm posing here. To what extent do partisan elections influence the outcomes, in my particular research question, of employment arbitrations? We'll get to that research in just a few moments, but again, a little more background will be helpful for us. Let me just see how we're going to go here. We need to talk about one other Supreme Court decision of even more